Good afternoon, distinguished ladies and gentlemen. Welcome to another enlightening, another intriguing session with Ascent Debt Recovery. And I remain your humble host, Benson Okezewosu, Esquire, bringing you another. Actually, this is not our regular session per se, because it deals more with the law, and I would have to come down to the specifics in terms of both the section of the law I'm to point out and how it relates to the subject matter I intend to talk about. So, without saying much, the topic is key points from the Nigeria Data Protection Act 2023 on debt recovery matters. So, what is the law that I mentioned? The Nigerian Data Protection Act of 2023, and what is the subject matter? Debt recovery matters. Now, I'm sure those of us who are current with the affairs, with the Nigerian affairs, have at least heard about a data protection law that our president signed into law, and the law itself specifies on the issue of data protection. Now, data protection, data itself here simply refers to any form of personal information. So let the word data let it not confuse you. What is being made reference to are personal information of any cadre. It could be your name, your age, your marital status, your current standing socially, economically, or otherwise. Basically, any information that is about you as a person or about anyone as a person. Now, person here being both natural and artificial persons. Natural persons being you and I as human beings, and artificial persons being a company, a business name, as the case may be. So far as that information can be tied to someone, can be tied to a person in whatever form, that is data. So, one may ask, how does this relate to debt recovery issues? Let me explain. Now, when we talk about debt recovery, you do remember, as has been reiterated on several sessions, that debt recovery requires two persons. On one hand, you have the creditor, the person from whom money leaves, and you have the other person being the debtor, into whose hands the money enters. So, I know we haven't really done a session on the step-by-step process of how debt recovery happens. Maybe that can be sorted out subsequently. However, the little detail is this. I'm a creditor, and I have person B who is interested to secure credit facilities from me. That's money, that's funds. Obviously, I wouldn't just supply any amount as the person requires. I would require certain information from the person. What are those information? His name, his current employment status, where he lives, probably if he's married or not, and in addition to his current employment status, which is preferably that he's employed, I would also need the information of his employer, and to sum it up, I would need the information of a person known as a guarantor. In a previous session, I know I mentioned that it's not in all cases that a guarantor is needed, but as a matter of practice and, just to set things in motion, or for the sake of, maintaining the practice, most credit companies require a guarantor. So, and the other person, that's the other information I would need. So my point here is, I wouldn't just cross my leg and supply any amounts that anyone may need. And I may even need further information with regards to his financial status, which are very sensitive information basically. So all this information I will be gathering from him, they are all data. They are his personal data. His name is his data. His employment status is his data. His current house address is his data. His phone number, his email, his social media handle, any information that can be tied to a person, like I have initially stated, is his data. So, I mean, being that, and mind you, this data is usually collected by the creditor because they are the ones with things to lose. I mean, a debtor who ends up not paying his debt basically has nothing to lose, because even if anything, he gained. So the creditor is usually the one who is burdened with having to obtain this information from the supposed debtor, so as to make sure that he keeps tabs on him and has the proper information to reach out to request for satisfaction of debt, as the case may be, or when the case arises. So most times, again, when it comes to the issue of recovering debt, sometimes two sets of people can recover. Well, I won't even regard them as two different categories. However, I'll just call them two different persons, because they're not the same person per se. Person one, the creditor himself. That's the first person, that's the first line of data supply, basically. And then you now have the debt recovery agency, debt recovery institution, by any name that they may be known by, which is the second person that I spoke about. And obviously, at that point, the moment a creditor acquires the services of a third party, being the debt recovery agency, obviously this data, or rather the data of the debtor, will be passed from the creditor to the debt recovery agency, so as to enable him facilitate debt satisfaction. So from all this information I have supplied, you can see why this act relates to debt recovery, especially relating specifically to the creditors and the debt recovery agents or agency, because they are the ones who are usually in custody of the personal data / information of the debtor. So the intention of this session basically is to pick out the relevant sections of that act. The act here being the Nigerian Data Protection Act 3, and how it relates to debt recovery matters. So obviously each of these sessions, I'm going to pick them out and relate them as they relate to them. Now, obviously, you wouldn't expect me to read out the acts or the provisions of the acts word for word. However, I would give you the idea that each of the sessions as enumerated here applies to you. Again, these sections I'm going to point out are specific to all creditors out there and debt recovery agencies / institutions / forums out there who deal with the data, private or public data, or any form of data of a debtor or anyone at all that is into the business of loan agreements and involves a debtor or creditor at some point in your transaction. Number one, we have section 24, which basically relates to principles of personal data processing. Now, here is that any data collected should only be used to the extent to which it was collected. Let me give an example. Again, there's this practice. I've done a previous session on broadcasting the personal information of debtors and the position of the law on that. I've done a session on how we have creditors out there or debt recovery agents out there who intentionally sabotage the debtors by putting out their information out there with the most defaming, with the most slanderous write-ups, painting the person as who he or she is not, just to prompt the person to pay. Now, the moment you as a creditor, the moment you as a debt recovery agent toes that line, you have used that personal data outside its intended purpose. Why? when you obtain the data, the essence was for you to have the means of reaching out to the debtor, probably to prompt him to make payments as the case may be. So obviously that's why you collected such data from the person. And mind you again that the reason you also collected the information of a guarantor is because the moment the debtor fails or stops reaching out to you or responding, that's where you can now go after the guarantor, because as a guarantor, again, we've done a session on the true legal position of a guarantor in a loan agreement, and your position is to satisfy any and every unsatisfied debt owed by the debtor, and it is an absolute form of satisfaction. You can't choose the part of the debt of a debtor to settle as a guarantor. So the moment you start using that data, publishing it, reaching out to all the contact lists as provided, you are beginning to act outside the intended purpose of collecting that data. And the moment you start doing that, you are basically in breach of section 24 of this act. The second section here is section 28, which deals basically on data privacy assessment. The point here is, when you collate the data, your job as a data controller, your job as a data processor is to this data you have collected, what is its intended purpose? One, how would it be processed in a manner that would not be detrimental to the data subject, being the person or the owner or the owner of the data? These are some of the things that guide your assessments. And in line with section 24 again, some of the principles that guide that personal data processing includes lawfulness, fairness, transparency, purpose limitation, as I've just explained, data minimization, accuracy. I mean accurate in the sense that the data should not be fabricated or altered, basically, and so on and so forth. Accountability, confidentiality, of course, confidentiality. All correspondence between two parties are protected by confidentiality. In other words, you can only reveal it to themselves or reveal it to any party as agreed by both of you. In this case, a guarantor. The next section here would be section 33, which is on data protection compliance service, which basically states that all form of data processing should be in line with the provisions of this act. Now we have this act goes further to specifically protect a child, because in terms of capacity to contract, the general rule with regards to a child is that a child lacks the capacity to contract. So section 31 of this act just simply connotes that the moment the data of a child is involved, that obviously consent of the parents and consent of the guardians of the child is of paramount importance. This act just shows us that everything that involves a child should be taken with great integrity and great protection, because the Child's Rights Act 2003, I guess, or if I remember correctly, the essence of that act is basically to protect. The foundation of that act is that the welfare of a child should be of paramount importance in every activity, in every decision making, in whatever form that involves a child. And it is very encouraging. I congratulate our legislators for imbibing this principle I just mentioned on the Child Rights Act in this section, because it basically protects the data of a child. Now, this next aspect I'm going to discuss on. The first aspect I mentioned are sections that deal with protection of data itself, as I've stated. Now, the next aspect of provisions I want to discuss are on rights on data protection. Now, previously, there was a session rather, I don't like to personalize, because we act as a team here. So, there was a session that dealt with the rights of a debtor. And in that session, some of the rights that were pointed out are: number one, the right to dignity of human person, the right to be free from harassment, right against discrimination, and right to privacy. So basically, every provision that's going to be noted here are rights that at some point or in one way or the other links up to the previous session on the rights of a debtor. Now, one of such sections is section 35 that deals on withdrawal of consent. Now, the idea is this: the same way a debtor supplied his information to you, he should also be free in that same manner to withdraw the consent to that information. Sorry, what I was going to say was, the same way a debtor gave his consent to the creditor to process his data as agreed, is the same way that that consent can be withdrawn without ridiculous conditions being made. However, the difference in this case would be that, number one, obviously when the debtor is in breach of the agreement, the creditor is free to reach out to the guarantor and fill the guarantor in on the probably negligent attitude of the debtor and the debtor's failure to satisfy the debt. To that extent, the debtor does not have the right to say that you wouldn't want your personal data to be divulged to your guarantor, because the moment you brought in a guarantor, you basically forfeited your right to complain against supplying your data to that guarantor. However, where the creditor now begins to act outside, maybe where the debtor has not defaulted in making any payment, or all of a sudden the creditor makes some or includes some form of ridiculous clause requiring immediate payment, meanwhile that was not what was agreed on. At that point, the debtor is free to withdraw his consent to the creditor from processing the data again outside what has been agreed. So the moment the opposite of what I have just described in terms of withdrawal happens, you as a creditor, as a debt recovery agent, or in any capacity, so far as you are dealing with the data of a debtor, or even the data of the creditor as the case may be, or in whatever form it may be, the moment you begin to act outside what has been agreed on, at that point, you are in breach. The next point is sex of a data subject. That's basically what I set out here. And one specific point to be made out here is that this section sets out, that's section 34, this section sets out the rights of data subjects, that's the person who owns the data basically, to make complaints to the Nigeria Data Protection Commission. What is the point being made here? For every creditor out there, for every debt recovery agent out there who is in the practice of broadcasting the details, the personal sensitive details of a debtor, simply because the debtor is in default, forgetting that there are other means to recover this debt, as has been dealt with sufficiently in previous sessions on this channel. The moment that is done, every person, every owner of that personal detail is free to approach the Nigerian Data Protection Commission to lay sufficient complaints as to the abuse of his personal data. Now, The next section here is section 38, which deals with personal portability, and permits me to read out. Data portability is the right of data subjects to obtain and reuse their personal data for their own purposes across different organizations, because it gives data subjects more control over their personal data and allows them to move their data to a different location if they are not happy with the services currently rendered. Now, the ending there obviously does not necessarily suit the question of debts, or the question of loan agreements involving a debtor and a creditor, because obviously the only time that a debtor is basically free from his obligation is when he or she or it, in the case of a company, business name, or any registered person, of course, is when he offsets and satisfies the debts being owed. That is what ties him to the creditor. But the point being made here is, obviously, if the creditor, in the bid to obtain his, make sure that debt is paid, and does something drastic, and hopefully and fortunately the debtor is able to is able to offset his debt. If there's a need to borrow again, you can be rest assured that that creditor has lost a potential customer. Because the truth is, as a creditor, as a loan agency, what gives you money is lending out these funds in your custody and getting the commission, the principal back, in addition to the interest. So because you have one customer who probably, through an act of God — now I'm not talking about those who willingly and unintentionally refuse to pay this, I'm talking about your regular customers who probably have some act of God. That's why ethical debt recovery is the best, because you put yourself in the shoes of the debtor. You even suggest ways the debtor can source for funds, set his debt. That way, you've not just helped someone out of a burden, you've also formed this personal relationship with that debtor. And believe you me that if there's any need for loan or any other service to be rendered, that you would be approached again. So that's how this works. We get it. You are trying to offset, except for very stubborn debtors. We are talking about the exception now. We're talking about the general rule. Things may happen. We are talking about money here. Anything can happen. The container may have capsized. The goods may have caught fire. Anything could have happened. So it is always best to liaise and engage with the debtor outside the regular debtor-creditor arrangements and come down to a more mutual level where everything will be cleared up. So without dwelling much or without going further, the essence, the whole idea of this session is to let you know that data should always be treated as intended, as should be protected. Basically, the moment any act is in contravenance with any section I have mentioned, in addition to other sections you would see in this act, you have basically gone contrary to it. And obviously there are clear sanctions for such here, because if there's a forum, there's this principle of law, is that when there's a wrong, there's a remedy. So there's no way you can wrong a person by defaming the person or acting all callous and expect that what's this word now? That the law would not come against you at some point, especially with these acts being in force. So that's the whole point I'm trying to raise here. So, in summary, always ensure that the data collected is used as intended. If, God forbid, you come across a debtor who is unwilling to do his bidding, you can either explore ADR or you explore litigation. And I have mentioned so many times the summary judgment procedure, which is a very straightforward procedure. And for jurisdictions outside Nigeria, you can come under the undefended list procedure, and the judgments will be held in your favor, obviously, when the proper processes and exhibits are before the honorable courts. Every court is a court of justice, so definitely justice will be done in your favor. So do this, and I believe that transactions will definitely go smoothly. So that'll be all for the day. Thank you so much. I remain your humble host, Benson Okeziowosu, Esquire. Have a lovely weekend.